following landlord and tenant educational models were developed as a community service in partnership between the City of Hutchinson, the United Way of Reno County, and the Housing and Credit Counseling, Inc. of Topeka, Kansas. A series of 8 educational models were developed and produced by HCCI to identify and address frequently raised landlord and tenant issues in the Hutchinson area. Topics included in the 8 educational models include topic of leases, security deposits, notices, evictions, move-in, move-out inspections, renters' rights, abandonment, and pets, companion animals, and service animals. All information discussed in the landlord-tenant educational models can be referenced in the Kansas Residential Landlord and Tenant Act, or the KRLTA. Module 7, Abandonment. In the state of Kansas, when you're talking about abandonment, there's various rental housing laws that are applicable. Most notably, the Kansas Residential Landlord and Tenant Act. And in the city of Hutchinson, there's a city code that adopted the International Property Maintenance Code, or the IPMC. Also in the city of Hutchinson, they adopted Chapter 3 of the City of Hutch City Code, which establishes a Human Relations Commission, and the commission addresses discrimination in housing, employment, and public accommodation. In Hutch, you can access the city code at www.hutchgov.com. We mentioned the KRLTA, the Kansas Residential Landlord and Tenant Act. We mentioned International Maintenance and Property Code, the IMPC. We mentioned fair housing with the City of Hutchinson, Human Relations Commission, Chapter 3 of the Code. Also, these laws are included in all the codes in the rental housing laws in Hutchinson. Again, the most applicable is Kansas Statute Annotated 582540, the KRLTA. Under the Kansas Residential Landlord and Tenant Act, KSA 582565, the topic of abandonment is discussed. The general application is that of extended absence of tenant, discusses damages. The statute discusses entry by the landlord. It discusses abandonment by the tenant. It says when it is reasonable, efforts must be made to rent as required. It also discusses termination of rental agreement. When personal property of tenant is discussed, and it discusses disposition, procedure, proceeds, and rights of a person receiving property. The term abandonment is a pretty broad term. So what is considered abandonment by the tenant? Well, under KSA 582465, extended absence of tenant is discussed, but what does that mean? What does extended absence of tenant mean? That's why it's important for all to understand what is meant when 582565A discusses abandonment. And in this section, it states, if rental agreement requires tenant to give notice to landlord of an anticipated extended absences in excess of 7 days as required by statute, and the tenant willfully fails to do so, the landlord may recover actual damages from the tenant. Okay, abandonment and damages. Under Section A, when statute refers to damages, in this instance, it is referring to any set of circumstances that results in damage to property as a result of tenant's abandonment. For example, if a tenant were to leave a rental unit unattended for a period of 7 days or more and the pipes freeze, or if there is a break-in and doors or windows or locks are broken, vandalism occurs, etc., whatever, the tenant would be responsible for all damages. So under Section A, when it refers to damages, this is what they're talking about. Anything that happens in the absence of the tenant. Under the abandonment statute, it also discusses entry by the landlord. Question would be, when can landlord enter your dwelling under this section of abandonment? During any absence of the tenant in excess of 30 days, the landlord may enter the dwelling unit at times reasonably necessary. This is a pretty broad statement. Landlords can enter the unit at times reasonably necessary. What does that mean? That's what you're going to run into when you go to court and trying to define when is it reasonably necessary. If it's different from person to person, from landlord to landlord, tenant to tenant. So be prepared to be able to answer those questions. Continuing with when can landlord enter the dwelling, if after the tenant is 10 days in default for non-payment of rent and has removed a substantial portion of such tenant's belongings from the dwelling, the landlord may assume that the tenant has abandoned the dwelling unless the tenant has notified landlord to the contrary. So if I'm the landlord and I know you have not been there in at least 10 days, and I go look in your window and I don't see a whole lot of your personal belongings, I'm going to assume you're gone. You've abandoned the place, and therefore, as a landlord, I have the right to enter. Further definition of abandonment is when a tenant is 10 days delinquent with rent, when a substantial portion of belongings are removed from the tenancy, or where no notice was given to the landlord from the tenant. Tenant is gone. He did not give the landlord any notice, so the landlord is left to assume whether or not the tenant is there or is not there. Abandonment continues to be defined when reasonable effort to rent is required, termination of rental agreement. These are other specifications in the statute. Reasonable effort to rent by the landlord after the tenant is gone, and whether or not the agreement continues to be in place or if it's terminated after abandonment. In Section C of 582565, if the tenant abandons the dwelling unit, the landlord shall make reasonable efforts to rent it at a fair rental. Continuing with Section C, the rental agreement is deemed to be terminated by the landlord as of the date the landlord has notice of abandonment. If the landlord fails to use reasonable efforts to rent the dwelling unit at a fair rental, or if the landlord accepts the abandonment as a surrender, then it is a given that the agreement is terminated. Continuing with C, if the landlord rents the dwelling for a term beginning prior to the expiration of the original rental agreement, it is deemed to be terminated as of the date of the new tenancy. If a property is abandoned, the landlord goes out and re-rents it, then that agreement is terminated as soon as the new tenants enter or a new agreement is met with the new tenants. Abandonment section continues under 582465 and it discusses the personal property of the tenant, the disposition, procedure, and proceeds and rights of a person receiving that property. When it is abandoned and people leave property, what are their rights? If a tenant abandons or surrenders rental unit, leaves behind personal property, possession is returned to the landlord by court action. Tenant's personal property is still in unit, it still goes to the landlord. If the tenancy is from month to month or week to week, the term of the rental agreement for this purpose shall be deemed to be a month to month or week to week, as the case may be. What's the responsibility of a landlord under abandonment? Well, the landlord is to store the tenant's personal property for no less than 30 days. Another aspect of obligation by the landlord is that he must publish an ad in the newspaper 15 days before disposal of tenant's property. Also, landlord is to send a copy of ad to tenant at last known address within 7 days notice, which appears in the paper. It is suggested that all amounts due should be included in this notice. If the tenant can pay before the disposal date of the property, the landlord is obligated to release the property of the tenant. Another aspect of property when it comes to abandonment and tenancy, some tenants rent from Rent-A-Center or rent TVs or furniture or whatever. All of that property is called secured property and must be returned by the landlord to its legal owner. In this case, it could be Rent-A-Center or something, other business that does similar types of rentals. After abandonment process is completed, judgment is made, dispossession is met, the landlord may dispose of the tenant's personal property. Landlord can choose to keep it, sell it, give it away, throw it away, whatever the landlord chooses to do with the tenant's property. If there is any proceeds from sale of property of the tenant, landlord may apply proceeds to rent due, damages, or unpaid balances. If there is questions or there is disputes regarding abandonment proceedings with the landlord, tenants have the right to file in their local district court under limited actions or small claims. You need to understand there's a $4,000 limit to this court for money or recovery of property. It's a self-representation court. Usually there's no attorneys. There can be, but usually there is not. There are filing fees. And some courts have opportunity for filing fees to be waived based on poverty affidavits. There's a limit of 20 claims per year per individual. And again, you have to go to your local district court in the county in which you have been renting to file these claims. All individuals involved with rental properties, landlords and tenants, have rights and also have responsibilities. To learn more about HCCI and HCCI's services, including landlord and tenant information, publications and forms, or if you need to speak to a landlord-tenant counselor, please call 785-234-0217 or go to www.hcci-ks.org.